Welcome to our panel discussion on digital assets and the securities law. My name is LizAnn Eisen, and I'm one of the acting professors of the practice at Cornell Tech and Cornell Law School. In addition to being on the Cornell faculty, I was a partner for many years at a New York law firm called Cravath, Swaine & Moore, LLP, and I was the deputy director of the Division of Corporation Finance at the Securities and Exchange Commission, where I, along with a team of over 350 dedicated professionals, oversaw public company disclosure, among other things. Today, we are hosting the second in a series of 6 eCornell discussions on topics that are important for general counsels and boards of directors to consider. I have the pleasure of being the faculty director for 2 executive education programs at Cornell, one for in-house counsel that is happening in person in New York City in June, and the annual Cornell Tech Board of Directors Forum happening in person in New York City in October. There will be more information about each of these programs in the chat. Now is actually a good time to mention also that we welcome questions during today's program. Please put them in the chat. Today's topic is crypto. Why talk about digital assets or so-called crypto assets? It is certainly a polarizing topic. On one side, we can ask, is crypto something to be optimistic about to solve pain points in financial services and beyond? On the other side, we might ask, is crypto all a scam by fraudsters, lawbreakers, and grifters? Or maybe it is somewhere in the middle. I think it's safe to say that the ultimate outcome of whether crypto will, quote unquote, work, whatever that actually means, is an open question. In addition, though, to being fun to talk about, now is the time to lay the regulatory groundwork for oversight of an emerging area and to answer some of the more challenging questions about digital assets before it becomes impossible to change course. Today, it is safe to say that crypto comes up everywhere, from airports to sports stadiums, and the roller coaster related to crypto asset values continues to be front page news. Just yesterday, Bitcoin hit a record high of more than $69,000. Bitcoin's price has risen about 300% in the last 16 months after melting down in late 2022. So what's driving the revival of Bitcoin prices? One possible explanation is the SEC's January action to approve Bitcoin ETFs after more than 5 years of regulatory delay. Some might say it has even been longer than that. What is an ETF? It is a way for investors to gain access and exposure to Bitcoin without actually owning the virtual currency. Do investors want this disclosure? The answer seems to be yes. According to Bloomberg, as of the end of February, investors had put more than $7 billion into these Bitcoin ETF products. Even with this influx of capital, the digital asset industry is still facing regulatory headwinds, to say nothing of prominent crypto failures. Sam Bankman-Fried is set to be sentenced at the end of this month for his role in the FTX meltdown and ultimate bankruptcy. The SEC continues to pursue many companies that offer and sell digital assets for unregistered securities offerings. Is the SEC correct in its assertions about these unregistered crypto offerings? Today, we're going to step back and look at the legal analysis along with some recent cases. I'm lucky to be joined in this endeavor by Professor Charles Whitehead, who is the Myron C. Taylor Alumni Professor of Business Law at Cornell Law School. He is also the founding director of the Law, Technology, and Entrepreneurship program at Cornell Tech. He joined the Cornell faculty after a long and distinguished career in the private sector. Chuck held senior legal and business positions in the financial services industry in New York and Tokyo, including as managing director at Nomura Securities, Salomon Brothers, and Citigroup. I'm also happy to say we are both Cornell alums. Welcome, Chuck. I'm excited to virtually sit down with you today and talk about the regulatory framework applicable to digital assets. Let's start with the basics. The Securities and Exchange Commission is the agency charged with oversight of the offer and sale of securities and securities markets. How do we know if an asset is a security within the meaning of the federal securities laws?
Great. So thanks, LizAnn. And LizAnn won't say this, but we're really, really lucky to have her at Cornell Tech. So she's been fantastic. So what I'll do in terms of crypto assets and sort of the general background is we're going to start with some basics. And so with that, let's put up some slides to highlight some of the basic analysis behind crypto. And the issue ultimately, in the first instance, is a jurisdictional issue. It's a question of whether or not the securities laws apply. They only extend to securities. And so the question is whether or not crypto falls within this broad, somewhat amorphous definition. And we'll go through that analysis in a moment. Again, I think many of you are probably already familiar with it, so maybe it's a refresher. For those of you who are just new to this, it'll give you some of the background. So when we're talking about a security, this is a defined term in the Securities Act. There's a similar definition in the 1934 Act. There are certain particular items, certain particular instruments that are just spelled out as securities, notes, stock, things of that nature, which are identified as the kinds of instruments that probably most people in general would think of as subject to the federal securities laws. There are also, however, some catch-all provisions. This concept of an investment contract or an instrument commonly known as a security. Right? These are catch-all provisions that are not nearly as succinct or as well defined as what common stock is or what a note is. And the idea was quite simple. Smart lawyers, perhaps many of you, if there was simply a defined term, and the markets changed over time, or smart lawyers looked to change instruments over time to perhaps either jump in or jump out of the securities laws, it's going to be a lot easier to do that to the extent that you have simple black and white definitions. And so we have some of these catch-all definitions that are really intended to pick up the basic economics of the transaction, whether or not it's the kind of instrument, even if it's not denominated as a stock or a note, the kind of an instrument that perhaps on balance should get the protections of the federal securities laws. And for this, we're talking primarily about disclosure, anti-fraud rules, regulation of certain large participants in the market, like securities exchanges and broker-dealers, right? All of these things trigger off of this very basic jurisdictional concept of whether or not a particular instrument is a security. Now, one of the leading cases to look at this is the Howey case, which I think many of you are perhaps already familiar with. And the Howey case involved the sale of plots in a citrus grove. What this really was, there was a hotel next to the citrus grove. And you would have people, wary of the long winters in New York, in Ithaca, believe me, who would jump on a plane or somehow go down to Florida, and they would open up their hotel rooms, and there in front of them was this beautiful citrus grove. And the sales pitch was something like, bring home a bit of Florida when you return back to dreary Ithaca. The actual sales themselves were spelled out on a land plot, a plot diagram, and you would own a certain portion of the actual citrus grove. You would own 1 or 2 or 3 trees, right? It would be identified specifically as this is your part of the grove. But in fact, there were real restrictions on your ability to actually go into the grove. For example, you couldn't go in there and harvest the oranges yourself. You couldn't go in there and make sure that the oranges were growing properly, that they were watered properly. For this, you had to hire a third-party contractor. They were permitted to go onto the grove. The preferred contractor, the one that was being pushed, was an affiliate of the Howey Grove, a group called Howey in the Hills. And the idea was that you would rely on Howey in the Hills. They would go through and fertilize and do whatever was necessary to take care of the oranges. They would ultimately cultivate, pick the oranges, sell the oranges, and you would get a pro rata interest in the sale of the oranges. In other words, you weren't buying a portion of the citrus grove for consumption. You weren't taking the oranges back home with you, even though the oranges themselves were the guts, if you will, of the business arrangement. What you really were doing was investing in an entire enterprise. And the entire enterprise included the maintenance, the distribution of the sale of the oranges, and ultimately the distribution of the proceeds from those oranges. So based upon that particular circumstance, the Supreme Court came up with a series of factors to consider in deciding whether or not an enterprise that might otherwise not be denominated as a security, it might not even look like a stock or a note, but nonetheless, looking at the realities of the arrangement, should still get the protections of the securities laws. And so it's the four-part Howey test. And the first part, and these things, by the way, over time, these factors have been modified by lower courts, by the SEC. So this is sort of a summary of where we are. It's whether or not in the first instance there was an investment of money or some other consideration, and a common enterprise. Now, common enterprise, we mean some sort of shared enterprise amongst the various investors. It could be a common reliance upon, let's say, Howey and the Hills. It could be shared expenses. So in this case, the shared expenses of fertilizing and cultivating the oranges. It would also be the net proceeds. Everyone rises and falls together based upon whether or not the oranges are sold at a premium or not at a premium. So a common reliance tends to be a fairly passive reliance, is how courts have subsequently looked at this, that you're there as an investor. Again, you're not more actively involved in cultivating or managing the orange grove. There's an expectation of profit. In other words, you're investing because you expect to get a profit, not consumption. You're not actually going to get the oranges. Predominantly based on the efforts of others. Not exclusively. I mean, there may be some activity on your part that also supports the profitability of the arrangement, but you're predominantly basing the efforts on, in this instance, Howey and the Hills, or whoever it is that's going to be involved in the day-to-day management, the growth, the sale of the oranges. Now, subsequently, there were some variations on Howey, the Howey case. And these become relevant because they give you a sense of what we mean by the business enterprise. In other words, the oranges by themselves are not a security. The plot of land is not a security. We'll see that there are other types of instruments as well, not a security, but packaged together as part of the totality of an enterprise was viewed as an investment contract, again, with the benefit of the securities laws. So Gary Plastic is a Second Circuit case. It's still good law. And it related to Merrill Lynch putting together an enterprise, a product line that involved investments into CDs. Now, CDs are not securities. They are deposits in a bank. So like oranges, if you simply looked at the CD by itself, you wouldn't say that the CD was a security. What Merrill Lynch did, though, is they packaged the investment into CDs with other types of services. So, for example, they checked the creditworthiness of the banks. They made sure that the banks were providing competitive yields. Ultimately, the plaintiffs argued they weren't competitive. That's why the lawsuit was brought. And they maintained a secondary market. They, very often, if you pull out of a CD early, as you know, you end up perhaps having to pay some sort of a penalty. You could go ahead and simply transfer interests through this Merrill Lynch platform. And so even though the CDs in and of themselves might not be viewed as securities, if you looked at the total arrangement, you saw an investment of money. In this case, the investment of money that was provided to Merrill Lynch to invest in the CDs. In a common enterprise, this common reliance upon Merrill Lynch to both assess the CDs as well as to create this secondary market so that you could transfer out of the CDs. An expectation of profit. I mean, clearly you were doing this because you expected to make money off of the investment into CDs. And most importantly, based on the efforts of others. The efforts in this case being the efforts of Merrill Lynch, the maintenance of the secondary market, as well as the ongoing monitoring of the banks and the CDs themselves. So this gives you some sense of the breadth of what an investment contract is. One of the concerns, and I'm sure we'll come back to this, is that perhaps it's a little too vague. We're talking about oranges from a case that is, 80, 90 years ago? We're talking about oranges in the context of trying to define what crypto is. And folks understandably are concerned that the ambiguities potentially around the Howey test may also give rise to either inconsistent or economically inefficient regulation of the crypto market. I'll kick it back to you.
Thanks, Chuck. Under the federal securities laws, as you've just explained, investment contracts are a type of security, and therefore their offer and sale must comply with the registration requirements. That said, the elements you've described, as you mentioned, especially the efforts of relying on others' efforts, sound like they require a facts and circumstances analysis. I can imagine that small changes in the way in which profit is earned can make the difference in that analysis. Would you walk us through how the facts and circumstances may lead to conflicting conclusions about whether something is a security or is not a security, and therefore may or may not be subject to the securities laws?
Sure, happy to do this. Let's go back to the slides again. Easier probably just to illustrate this with an example. And the example is NFTs, non-fungible tokens, in particular fractional NFTs. So I got to tell you, it's when I first became aware of NFTs that I realized just how old I had become. So the Bored Ape NFT, I will go to my grave not understanding why people invested in these. Actually, I do know why they do. They do it so they can get entry into parties with Paris Hilton. But NFTs are, they are a type of token. They're non-fungible. The idea being that each token is its own separate property or separate asset. And the question is, are there situations where fractional NFTs might, for example, go from being just simply an interest in an asset to perhaps being a security? So let's just use that as an example. And we'll start off again with fractional NFTs that give you a fractional interest in this example, a painting. It gives you some sort of digital certificate of authenticity that what you own is a 1/100th share or 1/1000th share of an interest in a painting. And we'll assume there are no royalties, there's no operating business. So in this scenario, the question is there an investment of money? Well, yes, right? I invested to get that 1/1000th interest in the Van Gogh. Is there a common enterprise? Well, yeah, right? We had to have 1,000 investors or whatever the number is in order to get the money collectively to go out and purchase that Van Gogh. So we're all commonly involved in this. Is there an expectation of profit as opposed to consumption based on the efforts of others? And arguably the answer in this case is no. Why is that? Well, I'm simply getting an interest in the painting. And perhaps in this first instance, all I'm interested in is saying to my friends, hey, I own 1/1000th of a Van Gogh. Perhaps it's for enjoyment. It's consumption, in other words. My interest in having and being able to, with my 999 colleagues, be able to view the painting. And the efforts are really our efforts, right? I mean, we've come together, we've put the money together, and the decision to buy the Van Gogh presumably was ours as well. And so on that basis, there's no operating business, there's no royalties, there's no expectation of profit. In this instance, all I'm simply doing is perhaps on balance doing more consumption than actual investment. So let's vary up the fact pattern. Let's suppose now that there are going to be, the expectation is at the time of investment, so at the time I put my money in, that in fact this painting is going to ultimately get sold. But it's going to get sold at a price and under conditions that are approved by, in this first instance, 51% of the holders. So now, again, is there an investment of money? Yes. Is there a common enterprise? Yes. Did I invest with an expectation of profit? Absolutely. Right? And the way this was presented to me was not that I'm going to simply enjoy the painting, but I'm going to invest because we're going to make a lot of money once we decide to sell this Van Gogh to some third party. Is it something that is based on the efforts of others? Well, arguably not so in this case, because the decision to sell, as opposed to hold and maybe find another buyer, hold, wait for another year or two to see if the price of the Van Gogh goes up, these are decisions that are made by us, those who put money in, not by a third party. And so arguably in this instance, it's not based upon the efforts of others. You can make arguments one way or the other, but I think on balance, people would say that because the investment was made by the investor, the decision to sell was made by the investors, those who put money into the painting, that on balance, perhaps you'd make an argument that it's not based on the efforts of others. Let's change that to where the decision is actually determined by a third-party manager. And we'll make it even more complicated. We'll assume that this manager also agrees to create a market for the buying and selling of these NFTs. In that instance, the decision to sell and at what price is based upon a third party, the efforts of the manager. The manager may also have been the one that collected funding in the first instance in order to, pool the money to buy the Van Gogh. And to the extent that I'm no longer interested in holding the NFT, the manager in this final example has created a market, will maintain this market as a way for me to realize value on my NFT by selling it to a third party. So we've gone from what started off as simply an investment for either consumption or enjoyment with no real expectation of profit, to now in this final example, an expectation of profit really at the time of investment based upon the efforts of the third-party manager and the market that this third-party manager has created. Let me just pause because LizAnn had mentioned there were some cases that are out there. There are a number of cases involving Coinbase and Binance. And what I've heard is that in both cases, there's been this question that's come up to the SEC, which is, are you saying that Beanie Babies are securities? And what they're really saying is, are you saying that collectible toys like Beanie Babies are securities? And the key answer, and I don't have the transcript, I'm not quite sure what was said in court, but I think the answer is, well, of course, Beanie Babies are not in and of themselves securities, just like oranges aren't securities, just like interests in a painting aren't securities. But that's not the analysis. The analysis is the totality of the arrangement. What was actually offered at the time the Beanie Babies were sold? Was it, here's a Beanie Baby, put it on your shelf, your kids will love you? Or here's a Beanie Baby, we're going to create a market for these Beanie Babies. We're going to push to increase the value of them. And at the end of the day, permit you to buy and sell and realize value. If it's the latter, it begins to look a lot more like Howie or a lot more like my NFT example, where it trips from being simply a Beanie Baby to now perhaps being something like, looking at the totality of the arrangement, something like a security.
Thanks for that description, Chuck. That was very helpful to hear you walk through the varying factors. As you said, Howie was decided a very long time ago. So let's look at some more recent cases that might help us understand how courts are applying the Howie test and analyzing particular facts and circumstances in digital asset cases. In fact, we've had a question from the audience, almost pre-guessing where we're headed. So hopefully we'll answer that about the Ripple case. In July of 2023, two judges in the Southern District, Judge Torres and Judge Rakoff, in the Southern District of New York, each in the same month issued what could be perceived as conflicting rulings on whether digital asset sales through trading platforms constitute securities transactions that are subject to the federal securities laws. In SEC versus Ripple Labs, Judge Torres held in part that Ripple sales of XRP to retail purchasers through trading platforms did not constitute securities transactions, while its direct sales to institutional purchasers did. In the same month, in SEC versus Terraform Labs, Judge Rakoff denied the defendant's motion to dismiss the SEC's claims that they had violated federal securities laws, in part by selling various digital assets to retail purchases through trading platforms. The judges seemingly reached different conclusions on the question of whether sales through trading platforms may constitute securities transactions. In both cases, the parties disputed whether the digital asset sales and distributions were investment contracts. Chuck, what do you think about these two cases coming so quickly on the heels of each other in the same area?
Yeah, so you're ahead of me. I haven't read the question. I suspect it's asking whether or not I think Ripple Labs was wrongly decided. So let me just jump to the conclusion, which is, yeah, I think it was wrongly decided. And Judge Rakoff in the parallel decision, I think his analysis is much closer to how I would think about it. But let's go through the two analyses. So we've got Judge Torres in the Ripple Labs case, and she's focusing on XRP crypto assets, and basically the analysis she's doing is the Howey analysis. And she's focused on whether or not there was a reasonable expectation of profit based on the efforts of others. So clearly there was an investment of money. Clearly there was a common enterprise. I don't think anyone is contesting either of those characterizations. Judge Rakoff, I think, would read it the same way that Judge Torres did. The real question was whether or not there was an expectation of profit based on the efforts of others. And what Judge Torres focused on was the difference in communications that she found to have taken place between institutional investors and retail investors. And the argument was, well, that institutional investors were given a lot of information about what it was that Ripple intended to do with the money that was being invested by these institutions into the XRP. And that retail investors were not given the same information, that they were buying somewhat in the secondary market. The funding wasn't necessarily going to Ripple, and they didn't have the same access to the kinds of information that Judge Torres found the institutions were aware of. This idea that with the funding that Ripple received, they were going to build out XRP, they were going to make it more of a standard in the industry, and as a result, hell, this thing is going to go through the ceiling. Everyone's going to make a lot of money. And so on that basis, she said, well, look, there was clearly an expectation of profit based on the efforts of Ripple as far as the institutions were concerned, but not so in the case of retail investors, those who might be buying in the secondary market, because there was no knowledge as to whether or not in the first instance the money was going to Ripple, and secondly, they weren't given the same insight into what it was that Ripple expected to do with the money once they received it. And so you end up with this very kind of odd result, where she said, well, XRP is a security because there was an expectation of profit based on the efforts of others as far as the institutions go. But as far as the retail investors who were buying on the exchange, because they didn't have the same access to information, it was not a security. There was no expectation of profit based on the efforts of others. Now, the one thing this focuses on is the factual nature, the circumstances around the particular investment decision that drives something to being a security or not a security. And so there's a lot of criticism that comes out of the crypto industry. I don't think it's so unfounded that you have to be focused on the facts, and different people may interpret the facts differently, and that does maybe at the edges. I don't think it's at the core of the Howey test, but maybe at the edges may create some ambiguity. The difficulty with Judge Torres's analysis is, I would think, twofold. One, the question really is, when you talk about the efforts of others, are we talking about an expectation that there will be profit generated by Ripple who will receive the funding? Right? If you understand the Howey analysis to say that you have to, as a reasonable investor, expect some sort of profit from the originator, in this case, Ripple, of the particular token based on the money received, well, on that basis, Judge Torres's analysis makes a lot of sense, right? Because the retail investors didn't have access to this information. To the extent that it's based upon the efforts of others, irrespective of whether or not they actually receive the funding, then Judge Torres's analysis becomes a little bit harder to justify. In other words, do I really need to know that Ripple's getting the money? Do I really need to have actual knowledge of this in order for this, as a reasonable investor, to be viewed as an expectation of profit based on the efforts of others? And I would suggest that by arguing by concluding, as Judge Torres did, that you actually had to know that there was use by Ripple, the originator of the token, of this funds to enhance the value of the token, that there had to be a correlation between the money going in and the efforts by Ripple to enhance the value, that perhaps she tied the two elements too closely together. That you could still be dependent on the efforts of others for value, even if the actual capital wasn't ending up in their hands. The other point flag on this is, it results in this kind of odd situation. So if I go ahead and sell an XRP token to an institution, it's not going to be a security under her analysis. They turn around and resell it to me. I'm a retail investor. I'm Grandma Whitehead. I don't know any better. It suddenly now magically becomes a security, or suddenly loses the value. It's no longer a security because I happen to not have the same insight into the particular investment opportunity that the institution had. I buy this security, I turn around and resell it to another institution, and now magically it goes back to being a security again. That can't be the right answer, right? It can't be dependent upon the particular holder at a particular time and what he or she knew or did not know. In fact, Howey doesn't make that distinction. And that's really the crux of Judge Rakoff's different analysis, right? So Judge Rakoff subsequently comes out in the Terraforms case. LizAnn was being very polite. He doesn't just move away from Judge Torres. He actually says quite directly, he doesn't buy the analysis. And he doesn't buy the analysis for just the reason I'm describing, that Howey doesn't make this kind of a differentiation between institutions and retail investors, that you're talking about a reasonable investor writ large and what they might or might not know based upon the way in which the particular token was being sold. The fact that Joe or Frank or Sally doesn't know something doesn't mean that it's any less or any more a security, just like if Fidelity knows something and Chuck Whitehead doesn't, shouldn't change the nature of the asset itself. I will say there's a lot of grounding in the securities laws for this way of thinking, even though it's not necessarily tied to Howey. This idea that you don't want securities to necessarily transform based upon the nature of the investor, it's something that you see in a number of cases that involve this jurisdictional question of what's a security. And so in that respect, I think Judge Rakoff's analysis is on balance the one that I would expect the Second Circuit and if it goes up to the Supremes to be more inclined to follow.
Thanks, Chuck. You were exactly right when you presupposed that the question was about whether you agreed with the Ripple decision. But now you mentioned cases going up. What is the current status of the Ripple case? Where do we stand now?
Yeah, so as I understand it, and I'm not directly involved in the case, but as I understand it, the SEC is not going after the individual defendants, meaning, for example, the Ripple CEO. There was a finding by Judge Torres that there was a Section 5 violation as it related to the institutional investors. So they are in the damages phase. I think briefs are due in May. And I fully expect the SEC to take this up with the Second Circuit. Certainly as it related to the retail, the programmatic sales on the exchange, that they're going to argue before the Second Circuit that this part of the analysis was perhaps consistent with Judge Rakoff's views, perhaps tying too much into what an individual might or might not know in deciding whether there was an expectation of profit based upon the efforts of others.
Thanks, Chuck. So, you mentioned treating purchasers of an asset differently depending upon whether they're an individual or an institution. Are there other scenarios in the U.S. securities laws where purchasers are treated differently depending upon their status as an individual or an institution?
Sure. So the answer is yes and no.
A true lawyer's answer.
Well, a law professor's answer, certainly. So why do I say this? Clearly, there are sections of the Securities Act as well as the regulations under the Securities Act that differentiate the treatment under the securities laws based upon the nature of the purchaser. I mean, things as basic as, qualified institutional buyers under Rule 144A, accredited investors under Regulation D. You also see it in the statute itself. I'm thinking now about new Section 5E, or relatively new Section 5E of the 1933 Act that deals with security-based swaps. And the way Section 5E works, you have to register a security-based swap unless the buyer is what's referred to as an eligible contract participant. An eligible contract participant it's actually defined in the commodities laws. but it basically is a financial institution or an entity that meets certain minimum asset requirements, maybe certain minimum net worth requirements, but really is by and large most likely investing for some sort of hedging purpose. And even though it's not spelled out quite this way in 5e, it's pretty clear that the intention here is to force sales of security-based swaps only to those who are going to use them in hedging transactions, right? No one's going to want to register these things, in other words. And so the idea is to steer them away from grandma and grandpa, not by outlawing them, but by imposing this heavy cost of registering them, steer them towards these eligible contract participants. So that's the yes part. Now, the no part is you don't really see this in the context of the definition of security. And that's an important point to make. To the extent that we are focused on the jurisdictional hook of whether or not you're a security, you kind of end up in the Judge Torres world to the extent that you define or redefine the jurisdictional reach based upon the nature of the investor and what he or she knows or doesn't know. And it ends up, again, with an odd result where, depending on who owns what at what particular time, you may or may not have the protections of the securities laws. What makes it particularly odd in the case of Judge Torres is the more sophisticated institutional investors get the protections of the securities laws because they have information. The less sophisticated investors who don't have the information, but presumably would benefit from the protections of getting information under the securities laws, are the ones that don't get the protections of the securities laws. So it's exactly kind of flipped on its head. And so I think the point here is we do have these types of differences. They tend not to be jurisdictional in the sense of defining the scope of what a security is, but we certainly do have different levels of treatment.
Thanks, Chuck. We've had a question from the audience asking why doesn't simply the definition of currency overcome this, is it a security, is it not a security? Why isn't it enough just to say that it's a currency?
So or another way of saying it is why don't we just simply focus on this as being a commodity, like currency, like gold, like silver, as opposed to this question of whether or not it's a security. And there are a few answers to this. I will actually go back to the slides in a moment just to highlight one of them. It's a great question. And it's really at the core of the fight, right, between the crypto industry and the SEC. So the first is remember, whether or not the instrument itself is a security or not a security is kind of secondary to the broader question of the business enterprise within which the asset happens to be sold. So oranges by themselves are not a security. They are whatever. Beanie Babies by themselves, not a security. CDs by themselves, not a security. Where they become a security is the way in which they are packaged and distributed. And so when you hear the SEC talk about crypto being a security, they're not talking about the electrons, just like we're not saying an orange is a security. What they're talking about is the totality of the arrangement by which the electrons are being sold. And either it's the distribution of the electrons, meaning there's an ICO, an initial coin offering, like an IPO, where there are clearly directed selling efforts. There's clearly an effort to promote the investment, create demand for the investment, provide an increase in value for the investment based upon the efforts of whoever is promoting the currency or commodity or whatever it is, right? That begins to look, again, less like a currency in and of itself, and more like the type of investment that the securities laws were intended to protect. Similar to this is the idea that I'm going to sell you some electrons, but say to you, look, I'm going to be out there beating the bushes and making sure people know just how great this opportunity is. So there's likely to be greater demand and more interest. So guess what? I'm telling you now, at the time I sell you these electrons, that this asset is going to appreciate in value. And oh, by the way, I'm going to create an exchange so that people can buy and sell these things. And a year from now, when your investment of $100 is now $10,000, you'll be able to realize this on the exchange, right? These are all, even though the electrons in and of themselves may not be a security, the totality of the arrangement, the business enterprise and your interest in that business enterprise is what makes it into a security. And I think that's the key point here. When the judge asks in the Coinbase or the Binance cases, are Beanie Babies a security? It's really not quite the right question. Oranges are not a security. The question is whether or not the totality of the arrangement that happens to turn on Beanie Babies is the type of thing that the securities laws were intended to cover. And to that extent, then we would drop it under the definition of security and something that the SEC would oversee. I'm wondering, LizAnn, does it make sense to talk a little bit about Bitcoin?
It does. I think, the SEC has been accused of quote unquote regulating by enforcement in the digital asset area. We've talked about the current state of some of the cases and enforcement actions, but let's turn to Bitcoin ETFs. The SEC in January approved the first spot Bitcoin exchange traded product. And, Chair Gensler, chair of the SEC, had some very strong words about what folks should take away from this approval of a Bitcoin ETF. In fact, he went so far as to say, and I'll basically read it. Importantly, today's commission action is cabined to ETPs holding one non-security commodity, Bitcoin. It should in no way signal the commission's willingness to approve listing standards for crypto asset securities, nor does the approval signal anything about the commission's views as to the status of other crypto assets under the federal securities laws or about the state of non-compliance of certain crypto asset market participants with the federal securities laws. So, very strong statement from Chair Gensler in approving spot Bitcoin ETFs. Chuck, what do you think about the SEC's approval of the Grayscale spot Bitcoin ETP and others? And where are we going from here?
Sure. So let me first just address, the question of the SEC and Chair Gensler. I mean, the SEC is merit neutral, and I know there have been concerns that might not necessarily always be the case, but certainly in my experience, they are merit neutral. The focus is on assuring that there is appropriate sort of regulatory guardrails. And I think what Chair Gensler is saying is that many digital assets are securities, right, that they satisfy the Howey test, notwithstanding the fact that in the case of the Bitcoin ETPs, that they're going to approve their listing. Another way of saying this is, in order for the SEC to get comfortable that these Bitcoin ETPs were appropriately, the new rules permitting them their ability to trade on the exchanges was appropriately adopted, they had to conclude that Bitcoin was not a security. If it had been a security, then these would be ETFs. They'd actually be funds and subject to the Investment Company Act. They did not subject these ETPs to the Investment Company Act because the underlying asset was not a security. It's Bitcoin. It was not a security, and so the Investment Company Act provisions, the ETF, the fund listing requirements were not applicable. And so what Chair Gensler is clearly saying is just because we've let Bitcoin go forward and we're not imposing Investment Company Act requirements on these ETPs doesn't mean that we're backing off on finding other types of assets as being securities under the Howey analysis. If you don't mind, let's pull up my the slides again. And what I'm going to talk about a little bit is the SEC's approach in the context of crypto. This is a speech that it's somewhat famous or infamous now, depending upon which side of the table you're on, regarding crypto assets. And again, it starts off by saying, look, when we're talking about the digital asset, right, it's your question, right? The asset itself the person that asked the question, the asset itself is just code. It's just electrons. This is coming from the then director of the Division of Corporation Finance. He says, look, there are scenarios, however, where these electrons may, in fact, turn out to be investment contracts, the way in which the asset is sold, the extent to which, for example, there are concerted selling efforts in order to try to increase the value of the investment. He says in these scenarios, you'd expect the securities laws and the protections to apply, that you'd expect in these instances the types of disclosures that the securities laws otherwise would require, that they would be relevant to the extent that you're out there trying to affirmatively, deliberately sell these investment interests. Now, he goes on to then start to talk a little bit about whether or not at some point Bitcoin becomes so decentralized that you cannot be basing it on the efforts of others. In other words, he focuses on the network. And he starts to talk about the fact that network is a decentralized blockchain network. And so on that basis, Bitcoin is not a security. You're not dependent on the efforts of others because it's a decentralized network. And so there is no others, right? It's decentralized. And on that basis, Bitcoin would not be a security. And he talks about this both in the context of Bitcoin and later on about Ether, that the network, again, is decentralized. And so on that basis, it's hard to argue that there is a dependence on the efforts of others, again, because it's a blockchain-based network. And so on that basis, you shouldn't think of Bitcoin or Ether as being securities. Bitcoin more definitely, Ether perhaps a little less so, at least as far as this presentation back in 2018. And the question I would ask is whether or not in this instance the staff may have actually gotten it a bit wrong. Let me start by saying I have lots of friends on the staff. The staff is great. But on this one, perhaps the staff became a little bit too aggressive. And that's because the focus here was on the decentralized network, not on whether or not economically the assets were decentralized. In other words, when we talk about efforts of others, are we talking about the technology that underlies the asset? Or are we talking about others that might, as part of the enterprise, be involved in perhaps creating value for those who are investing in the asset? And what I would flag in the case of Bitcoin, for example, and here this may surprise you, I think the SEC may have actually been too lenient on Bitcoin by agreeing that it is not a security, is the fact that there is a significant amount of concentration in terms of ownership interests. And so the question would be, and it's a factual question, right? I'm not the one that makes the final determination, but it certainly raises the question as to whether or not there is a small group of economically incentivized people that hold a vast amount of the Bitcoin to push it as a means in order to enhance value, both for themselves, but also for third parties that may come in and obtain Bitcoin. If you believe that the decentralization of the technology is less relevant than the common reliance on this smaller group of people who have a strong economic incentive to enhance the value of Bitcoin, then arguably this begins to look like a Howey security. And you see this as well in there's other data out there that suggests that on balance, we're seeing large concentrations, economic concentrations, even if the technology is decentralized. And so on that basis, I would argue that perhaps Howey does apply to Bitcoin. Perhaps it does apply to Ether to the extent that there is a consolidated, focused effort on the part of a small group economically to enhance the value, even if the technology itself is decentralized. Another way of saying it is that there's a common enterprise in the sense that we're all dependent upon that very small universe of investors in order to enhance the value, really enhance the adaptation of Bitcoin and Ether more generally in the marketplace that results in an increase in the value for the investors. Now, there is a problem with this analysis, and so this will truly surprise you. The problem with this is that over time, we expect Bitcoin and Ether to, in fact, become like a currency. This is the question that was posed a few moments ago. And we do expect it over time to become tradable generally like a currency or like gold, not necessarily dependent on the efforts of others. Today, where we are, because of these concentrations of economic wealth, right, it looks much more dependent upon the efforts perhaps of that small group to enhance the price of the assets. But over time, as this becomes truly a decentralized and economically decentralized asset, perhaps at that stage it should no longer be subject to the securities laws. And you end up with exactly the problem that I was critical of Judge Torres's decision on, which is that an asset that is a security today, over time may become not a security. And to the extent that, God forbid, sometime in the future there are greater concentrations, again, maybe it flip-flops and becomes a security again. So the point here is simply that there is an ambiguity. I think it's actually a better ambiguity than what the crypto industry has been focusing on. Right? The crypto industry has been saying Howey isn't clear. I think the key point isn't that Howey isn't clear. It's that Howey can adjust over time based upon circumstances, and the nature of crypto is such that you can see an instrument today that is a security over time losing those protections, or vice versa. And that has implications not just for the investors in the Bitcoin, but also dealers in Bitcoin, also exchanges and the crypto assets generally, that may go from being regulated to not regulated, or vice versa, depending upon the characterization. And so to me, that would argue in favor of perhaps thinking about a separate set of regulations on crypto assets. So based upon the analysis that we have today, Judge Rakoff, I think, is right. Based upon where we are today, I think crypto, you wouldn't think of it as a currency. You look at the totality of the arrangement. But also because of the shifting way in which one might regulate this, this does argue perhaps on balance for a different way of regulating crypto.
So that brings me to another question, Chuck, for you. You know, the digital asset industry and the SEC really seem to be at an impasse. They are battling each other. Are there examples where industry and the SEC have worked together to find solutions in similar circumstances where there is an impasse?
Yeah, so I will say my experience, as LizAnn had mentioned, I practiced for a while, and I was both an outside lawyer and an in-house lawyer.
And now I'm going to interject, Chuck, and say you are being incredibly modest. You had a very distinguished and career as both a legal professional and a business person before joining ranks of academia.
Thank you. I would only point out that I'm actually 23 years old, even though I don't look that way, because of all the wars I've been through. But the point is, in my dealings with the SEC, almost without exception, the SEC has been quite reasonable in working through issues that are of concern, and that goes back to the earlier point. The commission is merit neutral. That's not to say that it doesn't sometimes feel like a battle. I mean, when regulation is enforced or imposed through administrative actions or court actions, it can be a little frustrating. But if you approach it correctly, and I would suggest that, at least from what I've seen, perhaps the crypto industry hasn't always been as consistent in this as they could be. When you approach it in the sense of, let's work out a way that will make all of us comfortable. We'll get business done. You as a regulator can be comfortable that we're doing it in the right way, that there's usually a middle ground. And I've seen this not just with regulators in the US, I've seen this with regulators in other countries as well. So one thing, for example, the industry might consider doing is looking to basically take on, but within the sort of more flexible guise of voluntary arrangements, the kinds of protections that you'd expect regulation to impose anyways. So segregation of accounts, things like minimum capital. Why not have within the industry, amongst the various crypto dealers, some sort of a jointly managed insurance fund? We see this among dealers, SIPC. This actually happened. I was in Japan with Salomon Brothers, and the Japanese government decided that there were concerns over whether or not assets were being properly segregated and protected in various accounts. And so they required the creation of a SIPC in Japan, an insurance arrangement jointly funded by all the different broker dealers. And what happened was the better, more suitable, more compliance-oriented broker-dealers got together and created their own private SIPC. There was nothing in the regulation that prohibited this, and so they created their own private fund. So what did this do? It meant that if you were a member of the other SIPC, you had to worry about guys not doing the right thing, investors not being protected, and God forbid they blow up. There would be a loss of money that would come out of my pocket because I was a member of that poor SIPC. If I'm in the better SIPC, the one with the better companies, the more attentive broker dealers, we're going to self-police. We'll probably self-audit. That's what we did. But it also means that the risk of there being an actual problem becomes much lower. So things like this, which are industry directed, that get to the issue the regulator is concerned about, and in the case of my SIPC example in Japan, actually creates a separating effect, right? You know who the better brokers are because the industry is telling you. The good guys are in this SIPC, the bad guys in that SIPC, right? That provides a real benefit both to the industry, right, in terms of getting business done, and it also gives comfort to the regulator. And so I'm surprised that you haven't seen this or something like this, where the industry gets together, figures out some basic standards of conduct. You know, think of it like FINRA for the crypto industry. Basic standards of conduct that they will police and enforce on themselves, independent of any sort of regulatory requirement. That's not a concession to the regulator. It's really a way to get business done in order to enhance the longevity of this business and not worry so much about, at least from the regulatory perspective, that people will find problems that will mandate the kind of enforcement actions that you're seeing the SEC bring these days.
Thanks, Chuck. I want to reiterate the point you made about the SEC being full of reasonable and exceptional professionals. I can say that both having sat across the table from them, but also having been at the SEC. There are many, many dedicated and exceptional professionals, particularly in the Division of Corporation Finance. So yes. Thank you. Thank you for highlighting that, and thank you for your ideas. This has been a wonderful chance to sit down and hear your thoughts and hear your recommendations. Hopefully some folks from industry are listening, and I appreciate your time. This has been wonderful, and we've answered our audience questions. So thank you so much for being with us today.
Great. Thanks very much for having me.